Hey everybody, it's your instructor, Ryan Bradshaw, and we're talking business law today, chapter 14, which is on securities regulation. Securities are financial instruments like stocks, bonds, things of that nature, corporate debts, and we're just going to go ahead and jump into it and get through. This is basically an introduction to the chapter and not meant to replace the reading. I say that every time because I want you to read the chapters. And so let's talk about a few things with regards to security regulations. All right, so companies came to recognize they needed legal counsel and internal systems to place to ensure that they were in compliance. The Securities Exchange Act of 1934 was created in order to create some oversight for these systems and companies. There were monetary fines in place, civil penalties, and in some cases criminal proceedings. So let's talk about some of these things. Insider trading, you've probably heard that term before. Insider trading means basically that someone is using information that is not available to the public, but is available to an exclusive group of individuals, that they can use that information to benefit significantly. I'll give you an example. Let's say that you know that a product is about to be launched by a company and it's going to create a lot of hype and interest and probably going to create interest in the stock for the company. That would be something where if you went in and bought stock in advance of that information being released to the public, that could be construed as insider trading. Another example is if you know a company has done something or is going to have some bad news come out, and you know that the public is going to look unfavorably on that company, you could go in and purchase shorts on that company, a short position, and benefit greatly if the company's stock price goes down. And so these are just a few examples of insider trading. So the book refers to it. Insider trading can be understood by what the SEC defines as buying or selling a security in breach of a fiduciary duty or other relationship of trust and confidence on the basis of material, non-public information about the security. Fiduciary means that you have a responsibility to act as an independent agent and not do things with your own financial interests at heart. The word fiduciary comes from the Latin word for trust and refers to someone who is charged with responsibility to act in the best interest of the other party, not in your own selfish interest. That material non-public information, meaning information of any kind that would impact the market price of security that has not been disclosed to the public, i.e. insider information. There's a great documentary on Netflix that I've been showing to a few of my classes. It's on Netflix. It's called Dirty Money. And the episode is, what is the name of the episode? It deals with pharmaceuticals. It's called Drug Short. And that episode talks about a pharmaceutical company that was doing things that were not illegal but highly unethical. They were purchasing patents from other companies or buying out companies using the patents on existing drugs to raise the prices of those drugs and force not pharmaceutical companies, but insurance companies and clients or customers to pay those exorbitant rates for drugs that they'd already been using. An example was, I think one pill went from $13 a pill to $750 a pill. So that kind of stuff is really unethical. Might not be necessarily illegal, but definitely there's some ethical dilemmas present there. When you're talking about people's health and well-being, some of these examples were life and death, where the person had to have that particular medication or it would be a life and death scenario. So there's some examples. There's one example the book talks about here. We're talking about Martha Stewart. She traded on insider information. And there seems to be cases that pop up a lot. There was a case that happened this year. Georgia has a Senate election coming up with a Senator Loeffler. She is one of the ones that has been accused of insider trading. Burr, the North Carolina senator, has also been accused. I'm not saying that they did insider trading, but there is an interesting relationship between the dates that they found out how serious COVID was and their stock market or stock positions that changed immediately after that. In Loeffler's case, she sold some companies that she thought might be impacted by COVID and bought companies that would benefit from COVID. So, like stay-at-home stocks. So, like I said, I'm not here to decide if insider trading did occur there, but it is interesting and worth investigating. So we'll just have to see how that plays out. I do think it's wrong for Congress people to purchase individual stocks and manage their own money while they're in office, because there definitely is a conflict of interest that can and does occur when Congress has the power to pass legislation and regulation that can impact the economy, impact companies, impact specific sectors, and Congress can benefit from that. Let's say that Congress is going to pass a law that prohibits a certain type of business from operating, or prohibits a certain process, or whatever it may be, and because of that, companies that are in that industry are going to suffer. Well, all a congressperson would have to do is go buy stock in industries that are outside of that would benefit from it, not the ones that would suffer, but the ones that would benefit, and then buy short positions on the ones that would suffer and watch their stock price go down while the senator or congressperson's stock or position would go up in value. So these are ethical dilemmas, and in my opinion, people that are in public office should be not managing their own money and specifically not buying individual stocks. If they want to participate in the market, there's a lot of ways to do that through mutual funds, ETFs, and other things that would remove even the hint of impropriety. If I was a congressperson, I wouldn't want any type of accusation that I had done anything that was inappropriate or even remotely in the realm of criminal. There's a couple of things in this first section. The Schedule 13D in the Williams Act amended the Securities Exchange Act in 1934 so that investors could have advance warning of possible corporate takeovers. If someone, an individual corporation, becomes the beneficial owner of more than 5% of the company's stock, that entity must file a Schedule 13D with the SEC within 10 days of the purchase. A beneficial owner is anyone with voting and investment power over their shares. There are a few exceptions that apply, such as a qualified institutional investor, large investors who are deemed to have sophisticated knowledge of securities such that they do not need the same level of protection as general investors. Insurance companies, state employee benefit plans, and investment companies are examples of qualified institutional investors who are allowed to report their holdings at the end of the calendar year. Insider transactions. Corporate insiders are those officers, directors, and beneficial owners who own more than 10% of the class of securities registered under Section 12 of the Securities Exchange Act of 1934. Corporate insiders must file a statement of ownership with the SEC to be in compliance, and as of August 27, 2002, the SEC implemented new rules that shortened the time period to report insider transactions. Some additional reporting requirements. Publicly owned companies that meet certain size requirements are called reporting companies. And per Section 13A of the SEC Act Securities Exchange Act of 1934, they must file periodic disclosures. There's a Form 10K, also known as the annual report, contains audited financial statements. This is basically to validate the numbers that they're putting out to make sure that people are getting audited from GAAP monitored or GAAP performed audits. Basically, that accounting firms that are following GAAP procedures in order to make sure that the audit is in compliance. As an example, Berkshire Hathaway, written by Warren Buffett and Charlie Munger, provides not only their opinion on their own operation, known as the management discussion, but also their thoughts on the overall economy. The Form 10-K is a large responsibility for a company because it must disclose the company's analysis of its financial condition, potential market risks, internal controls, legal proceedings, defaults, and other information that is deemed important for investors to make sound investment decisions. You want to be privy to knowledge about a company before you put your money into it. The Form 10-Q, quarterly unaudited financial statements. Even though they're unaudited, you still want to provide genuine material because eventually those numbers will be audited in the annual review, and you don't want those two documents to be conflicting. The Form 8-K, certain events require a company to file a Form 8-K, such as change in the company's officers, mergers, or declarations of bankruptcy. Proxy statements are documents that the SEC requires that shareholders of companies with securities registered under Section 12 of the Securities Exchange Act of 1934 receive to allow them to vote on issues that will be decided at stockholders' meetings. I've gotten a few proxies in my life. Basically, it's an option to vote on things like new officers or board directors, things like that. Ongoing responsibilities. Businesses must stay current with changes in securities laws that impact their liability and responsibility. The Exchange Act allows the SEC to make new laws, like it did in 2000 with Regulation FD, which stands for Fair Disclosure. In 2013, the SEC started to allow the use of social media channels in certain circumstances as a means of distributing information to shareholders. All right, got a little bit more. So, the Securities Exchange Act of 1934. In 1929, the United States stock market crashed and lost $25 billion, which is approximately $319 billion today. The stock market crash of 1929 was one cause of the Great American Depression in 1930, which caused the failure of nearly half of American banks, creating unemployment rates of almost 25% by 1933. These dire economic conditions created the need for breadlines, quite literally hungry people who waited in line at charitable and government organizations for loaves of bread, and shanty towns, or areas where families who had lost their homes lived in cloistered tents on the outskirts of cities. Farmers could not even afford to harvest their crops. I'm not going to go into this section. We'll just keep moving for time purposes. But the SEC, the Securities Exchange Commission, was created in 1934 to enforce its ongoing mission. The SEC is an independent agency of the United States federal government. It regulates securities laws and regulation. The first chairperson was Joseph P. Kennedy, the father of President John F. Kennedy. The SEC is led by 5 presidentially appointed commissioners and has 5 divisions: corporate finance, investment management, trading and markets, enforcement, and economic and risk analysis. The SEC also oversees self-regulatory organizations, SROs, or private organizations that create and enforce industry standards. The SEC makes new laws in response to emerging technologies. For example, Title III of the Jumpstart Our Business Startup Jobs Act in 2012 was added, and in it, Section 4A6 allows crowdfunding, or raising small amounts of money from many people to fund a venture or project. Usually over the internet, crowdfunding transactions are exempt from registration as long as the amount raised does not exceed $1,070 in a 12-month period. Secondary markets. The Securities Exchange Act governs secondary markets, or what it typically referred to as the stock market, in contrast to the primary market, which involves the initial sale of securities, such as an IPO, initial public offering. Secondary markets involve subsequent buyers and sellers of securities. One key difference is that the primary market prices are set in advance, while the secondary market prices are subject to constant changing market valuations as determined by supply and demand and investor expectations. For example, when Facebook initiated its IPO in May 2012, the price was $38 per share, and technical issues on NASDAQ complicated the offering. After the IPO, the stock traded sideways, meaning it stayed within a range that did not indicate strong upward or downward movement. However, Facebook stock has gone on to trade at values more than 4 times its initial IPO due to investor belief and expectations. Not all stocks go up in value after their IPO. Some vacillate between high and low and frustrate investors. All right, this is a good stopping point. Please continue to read. Make sure you do your homework, and I'll be in touch again soon. Have a good week.